Greco on behalf of the City of Miami. Seated at the council table is Diana Vizcaino. This is a straightforward case, but I must begin with the standard of review because what the appellant is asking this court to do is reweigh the evidence on whether or not cause was shown for the termination of the appellant, Mr. Exposito. Two issues. First, cause. There is no question, and the record is replete with evidence, the testimony of the city manager, testimony of the 3 officers who were demoted, as well as the current chief of police, that the former chief of police committed insubordination. He defied the city manager's directive to not demote the 3 commanders and assistant chief of police, and to keep the status quo and not make any changes to the senior staff. Until
Greco, what's our obligation? Is there an objective standard for what constitutes cause, which I take to be good cause? Is there an objective standard? And if so, are we obliged to enforce it? Or is the determination of cause one that's left to an overall analysis by the administrative body and to which we must defer? How do we define cause for good cause in this context?
I think that in a couple of ways, and I think part of what defined cause in this case is the facts that were established in the record, because the city manager told the police chief not to demote the officers and explained that what he meant was that he was to keep the status quo and not make any changes in the senior staff until the police chief got back. So in that sense, it is a factual question has been established in the record.
And is therefore not subject to our review?
Not at all, because the standard of review is whether there's any competent substantial evidence to support the city manager's decision. Exactly. So
even if we were to conclude as an additional matter that this was all just an unfortunate misunderstanding and misinterpretation of emails, because emails are amenable to multiple interpretations, even if we were to conclude that, on your version of affairs, the standard of review is such that there would be nothing we would be, it would be proper for us to do.
Exactly, because of the facts, because of the way the record was borne out and the facts that were established. I argue that, first of all, the definition, and I don't think we need to get there, but I'd like to make the argument anyway because it was made by appellant's counsel, that there is a definition of demotion that applies in this case. The definition of demotion that is stated in the civil service rules does not apply, and the reason is thus. It states in the civil service rules, demotion is a reduction in classification and status. We know that, we argue that. It further states, a demotion is used when an employee is found to be unsatisfactory in the employee's higher level or for disciplinary reasons. That is a standard that applies to classified employees, not unclassified employees. The difference being that classified employees are generally non-executive level employees. There's a definition in the charter. But it is without dispute that these 3, the 2 commanders and the assistant chief of police, were not classified employees. The standard, this definition of demotion does not apply to them. So therefore, it does not apply in this case. I cited cases that are factually different, but that show that the courts recognize that demotion is not just limited to a reduction in your job title or a reduction in your salary. The courts recognize that demotion can, a reduction in responsibilities, a reduction in prestige and status can certainly constitute a demotion, and that's exactly what happened here. So even beyond the factual argument, which I believe carries the day here, based on the deferential standard that this court is subject to, even as is a question of what constitutes a demotion, there should be no question that it was reasonable for the actions that were taken by the former chief of police to constitute demotion. And certainly, I believe the record establishes that they were in direct contravention of the city manager's directive.
At the end of the day, your position is that even if we were to conclude as an additional matter that there was a good faith misunderstanding, reasonable difference of opinion about what constitutes demotion, we would still be not entitled to act on that basis because of the deferential standard.
Exactly. I don't think you can reach that because of the deferential standard, because you're not here to reweigh the evidence.
No, I want to be clear on that.
And I want to point out that I don't think that the record shows a conflict in a misunderstanding of what was happening here, because there was an email that, because first of all, there is competent substantial evidence that the manager specifically told the former chief to keep the status quo, not make any changes, wait till we get back. I want to make sure there's cause in this set of circumstances. But there was also an email that was introduced into evidence without objection, that the chief knew and said that he understood the directive to be that he was not to make any changes to his staff. And I will quote that email because I think it's a significant admission in this case, which states that is his words. You advised me that I could not make changes to my senior staff at this time, and that you would let me know when I could do so. That email was sent out. That is an admission, and I really don't think there is any dispute, although any disputes wouldn't really be relevant because of the deferential standard, but I don't think there could be any dispute that there was directive was given.
Even without the email, it's your position that the city manager has, in effect, unfettered discretion in a context like this, does it not?
It absolutely is absolutely crystal clear from the city charter and from the city ordinances, and it's not disputed here. The city manager has absolute authority of supervision and control over the police chief, as well as all other employees in the city of Miami.
I understand that's your position, and I respect that, Mr. Greco, but I just want to know how you respond to Mr. Zosky's argument that the reason there's a clause requirement is because the charter contemplates that the position of chief of police is so important, and the stability of that position is so important, that it provides for a requirement of clause rather than simply consigning the matter in the charter to the unrelieved discretion of the city manager.
Well, absolutely. They had a hearing on it. I mean, otherwise the city manager would have been able to dismiss the former chief without a hearing. But the fact that there was a hearing, and the charter provides that the city manager suspends with cause, and then the quasi-judicial hearing is convened by the city commission to determine whether or not the charges are approved.
What kind of showing is required at such a hearing?
At such a hearing, I don't think that's relevant, because for this court's determination, I believe it wouldn't be more than a civil standard. It certainly wouldn't be anything more than a civil standard. And there's no evidence to demonstrate otherwise.
Could be a good deal less.
It could be.
If the city manager said at the hearing, look, I'm points out, we just don't get along, would that be adequate?
You have to look at I don't know. I mean, we're not really presented with that today, because the question really is whether or not I don't want to speak on other issues that might come up in the future, but certainly we're not here on that today. I mean, we had our charge. The charge was proven. The city commission, the majority of the city commission ruled, and this court, that comes with a presumption of correctness to this court, and certainly if there's any competent substantial evidence, and I suggest there's a lot of competent substantial evidence based on the 5 witnesses that I mentioned to support the commission's ruling, that has to be upheld. I do want to, yes? The 5-day rule. I'd like to get to that. It's important. I think that I'm absolutely certain that the definition and the interpretation that has been argued by the appellant of the 5-day rule is not only unreasonable but incorrect based on the plain language of the rule. The Section 26 of the Charter says that the city manager certifies the cause of suspension to the commission, who, within 5 days from the date of receipt of such notice, shall proceed to hear such charges and render judgment thereon, which judgment shall be final. Okay. There are 2 very significant reasons why. What this means is that the commission is to begin the hearing within 5 days, not conclude the hearing within 5 days. Number 1, the 5-day clause comes before the clause where the Section 26 says, shall proceed to hear such charges and render judgment thereon. Secondly, shall proceed to hear such charges, to begin to hear such charges. That is what proceed to means. And to ignore that language would be to essentially misconstrue Section 26 of the Charter. What that says is that the City Commission within 5 days shall proceed to hear such charges and render judgment thereon. The construction that is being advanced by the appellant ignores that language, and we all know the canons of statutory instruction require us not to omit language in an ordinance or a statute. So, based on the plain language of that statute, there is no requirement that they conclude within 5 days. even if the statute is ambiguous, which I do not believe it is, because I don't believe their interpretation is reasonable, the court is required not to accept an interpretation of the statute which is illogical or, I would suggest, absurd. This is a significant issue, as counsel has stated, and it was taken seriously. The parties were given the time they needed to flesh out these issues, and really, this isn't a situation also, I would point out, that lasted, more than, because I think it was 6 days, and the only reason they adjourned was because they went from Friday all the way into the middle of the night Saturday, and they weren't going to hear it on Sunday, and they finished it up with closing arguments on Monday morning. So this is certainly a situation where, even if you assume their argument, there really was no prejudice to them. But the city's argument is that this statute is clear on its face, and that even if it were to be ambiguous, that their construction of the statute cannot be accepted. It would be unreasonable. It would result in a lack of due process to all the parties on issues that are very serious. So based on that, based on the language of the of the so-called 5-day rule, the city complied with it by having the hearing well within the 5 days, and certainly with all due haste reaching a decision. This is hopefully I have a minute or two left, but this is
you have
8 minutes left. Well, this was a very important issue. I think in any writ of quo warranto, the court takes into consideration the impact of what would happen should the court grant the writ. I think the city, based on our brief and the arguments made today, that the city commission completely complied with the rule. There was abundant, substantial evidence to support the outcome, and that this court should affirm the decision of the city commission. I would point out that the city did make an argument below regarding mootness. I'm not going to argue the point now since it was denied pre-oral argument, but I would say that if necessary, we would ask the court to revisit that argument, and in any event, we ask you to affirm the judgment of the city commission. Thank you very much.